All right, so people may continue to trickle in, but we'll go ahead and get started. Thank you everyone for being here with us. We're really excited to sort of host the HLR's Spring SCOTUS themed event. So this is an annual event that normally occurs in person, and we're so thrilled that, you know, despite the circumstances, the online format has really allowed us to open up this event to a wider audience, which is really wonderful. So thank you for being here with us. My name is Becca Carey, and I, along with Anna Jezerun, serve as a Supreme Court co-chair for the 135th volume of the Harvard Law Review. And we, again, are just so thrilled that you're with us. We also want to thank ACS and the American Constitutional Society and FedSoc for the Federal Society for co-sponsoring our event tonight. So a little bit of logistics. To begin the evening, I will introduce our moderator, and then we'll turn it over to my co-chair Anna to introduce the rest of our panelists. And then there will be what I hope is a very lively discussion between the panelists that will be followed by about 15 minutes of Q&A at the end. And so we would greatly encourage everyone to participate in the Q&A box. So there's a Q&A box down at the bottom. So, you know, if you click the Q&A function, it should have a box that pops up and you can type your questions in there, which will get sent to Anna and I and the panelists. So again, we would really encourage everybody to participate and ask questions. And so without further ado, let's get started. And so we're so thrilled. Our moderator this evening is Professor Kate Shaw. Professor Shaw is a professor of law at the Benjamin N. Cardozo School of Law, and her research focuses on executive power, federal courts, election law, and gender in the law. Her academic work has appeared, among other places, in the Columbia Law Review, the Cornell Law Review, the Texas Law Review, the Georgetown Law Journal, and the Northwestern Law Review. And she recently published the book Reproductive Rights and Justice Stories with professors Melissa Murray and Reva Siegel. Her popular writing has appeared in the New York Times, the Washington Post, the Atlantic, Slate, and the Take Care blog. And she is a contributor with ABC News and co-hosts the Supreme Court podcast Strict Scrutiny. Before joining Cardozo, she served as an associate counsel in the White House counsel's office and clerked for Justice John Paul Stevens and Judge Richard Posner. And now I'll turn it over to Anna to introduce our panelists.
Hi, everyone. Thanks again for coming today. Our panelists this evening, we're so excited to host them all, are Katie Barlow, Josie Duffy-Rice, Sarah Isger, and Professor Stephen Mazie. Katie Barlow is the media editor for SCOTUS blog. She's a journalist and former lawyer at the large international law firm in Washington, D.C. As a journalist, she covered Capitol Hill with WTOP, including Justice Elena Kagan's confirmation hearing, as well as the Supreme Court with NPR's Nina Totenberg. She hosts a political podcast, Words Matter, and she also co-founded Circuit Breaker, a website that provided news and information about the U.S. Court of Appeals for the District of Columbia Circuit. As a lawyer, she practiced white-collar defense and civil litigation with a focus on the Anti-Terrorism Act. Josie Duffy-Rice is a journalist and law school graduate whose work focused primarily on prosecutors, prisons, and other criminal justice issues. Currently, she is president of The Appeal, a news publication that publishes original journalism on the criminal justice system. Josie co-hosts the podcast Justice in America. She's a 2020 New America Fellow, a 2019-2020 Type Media Fellow, and a Civic Media Fellow at the University of Southern California's Annenberg Innovation Lab. Her work has been featured in the New York Times, Vanity Fair, The New Yorker, The Atlantic, and Slate. Josie is a graduate of Harvard Law School and received her bachelor's degree from Columbia University. Sarah Isger is a staff writer and host of the legal podcast Advisory Opinions for the Dispatch, and a political contributor for ABC News. When it comes to explaining the most important events in law and politics, Sarah's experience on 3 presidential campaigns in all 3 branches of the federal government brings a unique perspective on the news of the day and unparalleled knowledge of how decisions in Washington really get made. Sarah most recently served in the Department of Justice as the director of the Office of Public Affairs and senior counsel to the Deputy Attorney General during the Russia investigation. She's backstage for more than half a dozen presidential debates as deputy campaign manager for the Carly Fiorina's presidential campaign. She's a graduate of Harvard Law School and Northwestern University and clerk for Judge Edith H. Jones of the U.S. Court of Appeals for the Fifth Circuit. Professor Stephen Mazie is a Supreme Court correspondent of The Economist and professor of political studies at Bard High School, Early College, Manhattan. His scholarship has been published in Polity, Perspectives on Politics, Field Methods, Theory and Research in Education, Review of Faith, International Affairs, and the Law Journal for Social Justice, excuse me. Professor Mazie has had op-eds in the New York Times, Washington Post, Boston Globe, and Slate, and he has appeared on radio and podcasts, including The Intelligence and Checks and Balances. He's a graduate of Harvard College and has his PhD in political science with concentrations in political theory and public law from the University of Michigan. So if all of our panelists could turn on their videos, and with that, I will hand it over to Professor Shaw.
Okay, so thank you so much to Becca and to Anna for organizing this event and asking me to moderate. I'm delighted to be here. So let's get right to it. Okay, so everyone on this panel does important work as an intermediary, an interpreter, a meaning maker when it comes to the output of the Supreme Court and the legal system more broadly. And that's really important work, right? It shapes the way the courts work and the law more broadly are received and understood by the broader public. It's often invisible work. It is definitely under-theorized work. So I'm really happy to have the chance to spend the next hour exploring some of this with you all, how we understand these roles as, Supreme Court and legal commentators, what expectations and responsibilities attach to those roles, how those roles have changed, whether there are ways in which they should further change. So as Becca said, we're going to talk for about 45 minutes. In the last 15 minutes, we are going to take questions from the audience. So please, if you have thoughts or questions along the way, drop them into the Q&A and we'll get to as many of them as we can in the last 15 minutes. Okay, so I think we have a lot of law students here. So I actually want to start by asking each of you just briefly, if you would, to just talk through your path from law school, or Steve from grad school, to what you do now. And, I mean by that, what you do that is public facing in terms of commentary about the courts and the law. Josie also runs an organization. Everybody else has lots of things going on. But in terms of the public commentary piece, how did you get from school to where you are now? And maybe Josie, I'll start with you, and then Katie, and then Sarah, and then Steve. I can cue you all before, but Josie, if you want to begin.
Sure. So thank you so much for having me. I'm so excited to be here. And the story of how I got from law school to where I am now begins with me not being really great at law school. It turned out when I went to law school, it just was not really for me, I think, in a lot of ways that we'll probably explore tonight. And so I left knowing I wasn't going to do real law in the way that they tend to describe it. I went and did policy work for a few years, and I found myself always frustrated by the limitations of the legal system, both substantively and procedurally, to really address serious problems, right? I mean, people would say like, well, this is just the way it is. And I'm like, but why is it the way it is? So I decided to try journalism for a few years. And now I'm president of the Appeal. My time at the Appeal has been really great, in part because it allows a little bit of both of these things, the ability to talk about how systems are, and the ability to talk about how systems should look, or, what is the possibility for change. And so, so it's been a lot of trial and error to get here, but but it's better than it was for law school for me.
That's great. Thanks, Josie. Okay, Katie, what about you?
So I took the perhaps backwards path of knowing that I wanted to go back into journalism after I went to law school. I went to law school to be a journalist in part because I felt like the law was inaccessible in a number of ways, and the translators, as Kate eloquently put at the beginning, were an important part of the court and its ecosystem and kind of explaining that to folks. So I went to law school to kind of learn the language of the law. And then I practiced for 6 years to become fluent in it, or as fluent as I could be in my practice, and with the intent of transitioning, which I just did last year, fully into journalism, although my law firm was very gracious in letting me start news websites covering the DC circuit and things like that. So that was always my intent, and I am now doing that, which is a lot of fun for me at SCOTUS blog in particular, and it's letting me take my broadcast training and kind of explore new mediums like TikTok, and work on explaining the court and its role and its functions in a different and somewhat truncated way sometimes. But this is kind of all the grand plan. Now it's just trying to make it work.
I definitely want to get back to TikTok at some point. But Sarah, how about you? What's your trajectory? Oh, you're still muted.
Oops. I love watching Katie try to explain like personal jurisdiction in less than a minute using visuals. It's like, it brings me a hilarious amount of joy. It's funny. I'm not sure I would have described it the same as Josie, but after hearing her explain it, so my first semester in law school, I just did not do well. And I sort of had this epiphany of like, I need to have a different competitive advantage, because clearly being, the Sears Prize winner was not going to happen. Torts in particular was a real sticking point for me. I did not get torts. So I left law school. I clerked for a year. I had been a campaign operative before going to law school, so I knew that I would do that after, to some extent. I really fell into the opposition research world. I loved that. And what's important to understand about opposition research for those who have watched a lot of movies or even The West Wing and stuff, it looks like we dig through trash cans or like follow people to find out who they're having sex with. That, to the extent that is opposition research, it's not what I did. I was sitting there going through, financial documents, deeds at old courthouses, stuff like that. And the fun part for me was that really my job was to actually be the voice for the opposition. The candidate knows what their plus sides are. They know what they want to say. My job in the room was always to know the other side's case better. And I love that explainer aspect of the role. I fell into comms very accidentally. I went in to interview for an opposition research job, and they offered me the comms job, which sits above the opposition research director in this case. And so I took it, and speaking of accidents, so that was an accident. And then I was neighbors with Reince Priebus. He was supposed to be on Fox and Friends one morning, got food poisoning. I did not give him food poisoning. So anyway, the car is sitting outside and he can't go. He literally is vomiting too much to get into the car. And so they asked me if I would get into the car and go do this Fox and Friends hit. And that was my first TV. And that's sort of how it happened. And so I really was enjoying the explainer aspect of my job. Can't even really say how much that I enjoy the TV aspect, but that it's an important aspect of wanting to be an explainer. After the Department of Justice, it became clear that my career in politics and as a campaign operative was certainly over for a variety of reasons, namely involving one of the two political parties not really existing in its former form. And so this has been just a total treat and surprise after leaving that partisan world to really get to explore the explainer world. And that's what the courts are so perfect for in a lot of ways.
All right, Steve, please go ahead.
Sure. Well, my path is also a bit accidental, as Sarah's was, but a very different path. I almost went to law school, but I'm the odd man out here, the one who did not go to law school. I decided that I really wanted not to be a lawyer, but to study politics and study political theory. So I went to graduate school. I got a PhD in political science, studied political theory and public law, and then started teaching those things. And then about 10 years later, I started doing a little blogging, and I found my way to The Economist, where I would blog occasionally about American politics and some Supreme Court cases. And there was one particular case that most of you probably know, Town of Greece versus Galloway in 2013, that fascinated me. And I wrote several blog posts about that. And I just decided, maybe I'll ask the US editor if I can go down to DC and cover an oral argument and write up the oral argument. And the very kind editor said, yes. He sent me down. I was very excited, very nervous, very naive. I arrived at the court like 2 hours before anyone else got there, thinking that maybe I'll get a better seat if I arrive early. I had no idea how things work. I did end up getting a good seat. I was in the alcove and I was able to see everything. And I wrote that article, got it in before deadline. The editor liked it. And he sent me back to cover a couple more cases that term. And 8 years later and 400 or 500 pieces later, I get to be with this illustrious group. So thanks, Anna, and thanks, Becca, for including the non-lawyer in the Harvard Law School event.
So the last thing you said, Steve, actually is a good segue. So you talked about going to the court to cover arguments. And I know back before we did everything from our homes or like our hallways or wherever we are, you went to a lot of Supreme Court arguments. I would see you there. I, in my capacity as a contributor with ABC, would go to a lot of Supreme Court arguments. Katie, I presume that I don't know if you've picked up this gig since you've been, since COVID times. I don't know. Have you been to arguments yet?
I had the lucky fortune of working with Nina Totenberg in law school, where a dream job as a law student, you just go to the court every day with Nina and then write about the court. So I had some fun doing that.
Okay, so you guys are sort of have been regulars at oral arguments. So there's like a cadre of journalists, right, who are in a press room on the first floor of the court, and then go into the court for oral arguments, and then race back to typically file stories quickly after, or go into the radio booths. So Nina has a tiny little wooden booth in a room next to the press room, and other radio journalists do as well, and the TV folks on the front steps filming. So that's the kind of setting of, kind of the traditional Supreme Court journalism at the court. And I was going to ask about sort of how you all understand your roles vis-a-vis both the court and the public. And actually, I think everybody, Katie, Josie, Steve, I think all use the term journalist. Sarah said explainer. So I gather you, and your background is in politics. And so I gather you don't think of what you're doing as journalism. But I'm curious how, maybe Sarah, I'll start with you, because it did sound like you sort of framed the work you do differently. How do you think about the sort of what you do in terms of the categories of, so the category is one thing. Is it journalism? Is it legal commentary? Is it opinion? So I guess the label I'm sort of curious about, and then sort of beyond that, how you understand both, again, your relationship to the court and to the public, and sort of the role of voice and perspective in the explaining that you do via either your podcast or on TV or wherever else you're sort of speaking publicly. And then I want to hear from others, but maybe Sarah, start with you.
That's interesting. I've never really thought of putting a label on it. So I think more about my audience and who I'm trying to reach. The audience for a podcast is, probably just over half are attorneys. Very few of them, however, practice at the Supreme Court. That being said, we do have a handful of federal judges, circuit, district, et cetera, state judges. And I am cognizant that they're listening, maybe more than I should be, but more that you never want to be presenting one side's argument unfairly, including a judge's side. Like, oh, the judge wrote this opinion, they were thinking of this absurd thing. You want to be very fair about how you're representing that, and it helps to remember that for some of them, they're listening, and you'll get emails that are like, that's not at all what I was thinking. Don't psychoanalyze me on your podcast. However, like 40% of our audience are not attorneys. They're experts in their field usually. I did this whole thing on chicken sandwiches. I went and tried all of the fast food chicken sandwiches, and the former director of menu management at Wendy's emailed me. He's like, hey, I'm a listener of your podcast. Let me tell you about how that actually works. And I was like, right, again, don't opine on things you don't know much about. So I think of my role as speaking to people who find Supreme Court appellate law interesting and are nerds about it. Like, they want to get in the weeds. They don't want the cable news version of how a case turned out. Like, they want to get into footnotes. I did a whole thing on fonts. But they want it to be interesting and stuff that I care about. So mostly when I'm picking topics and which cases to cover and which ones to skip, I really just decide whether this is something I think is super interesting and fun, and I want to read all the footnotes, and I want to dive in further and go down that rabbit trail. It's very funny when Google v. Oracle came out. I told the pod, I was like, guys, I know this is a big deal case. I just don't care. And I got so flooded with emails and stuff of people making me care about it. I was like, well, that is interesting. I ended up doing 2 podcasts on it since then, including like this Hamilton remake that someone did, and fair use doctrine. So my sort of thought is, if it's a passion of mine, the audience will come along, because people are most interested in the stuff that you find interesting. I don't know if that really answers your question.
No, it's great. No, it's really interesting. It's
what to pick from.
Yeah. I know. And the beauty of a podcast is like it sounds like there's both like a demand side attention, like you're interested in trying to figure out. And I'm curious how you know the metrics so kind of granularly in terms of who listens. But we can have a side conversation on that, because I am very curious. We have general sense of who listens to our podcast, but I don't know at that level of detail, sort of the backgrounds of the people. But maybe there's just a lot. So maybe I'll shift the question a little bit. So maybe Steve, let me ask you. you're a, obviously you teach, but also you are a journalist. Although I think you, as the one I think of as, clearly a journalist, didn't necessarily use that term in the way you describe what you do. But assuming that is what you do, is it different from your colleagues at The Economist in terms of the sort of journalism that you do? Insofar as you've thought about that. And also just I'm curious about the role of voice and perspective and balance that Sarah was alluding to. How do you think about those kinds of considerations when you're sitting down to write a piece?
Sure. Well, one of the first things I'd say is that our audience is very different from Sarah's, and we would not be, if I pitched a story about fonts, that would not be too well received. What we're trying to do is to tell the story of big cases to readers who are intelligent but are not lawyers. So we try to avoid as much jargon as possible, to present the issues clearly, to have balance, right? Not to just present one side of the argument clearly, but on the other hand, when the question of voice comes in, we are trying to provide a way for readers to think about a case that's more than just, here's what the respondent said, here's what the petitioner said. So we want to give them a grip on the issue. It's not quite an opinion piece, but it's a perspective that we want to share with our readers. So it's not fundamentally different from what other Economist writers are doing in their stories. In fact, The Economist famously has no bylines. It has a single voice. And the perspectives that I take on oral arguments and on decisions are generally the ones that end up as the bottom line in a piece, but sometimes there's some negotiation. Usually it's me, of course, giving in to what The Economist's voice is, since I'm one and they are many. So in those cases, when there's something that I want to communicate about an issue that doesn't seem appropriate for The Economist, I'm able to turn to other outlets like the Boston Globe or the Washington Post, where I have written op-eds recently. And there it can be a little more pointed.
So let me turn the question a little bit for Katie. SCOTUS blog is so interesting because, it's not, legacy media in a traditional sense. And yet when it comes to the Supreme Court, it's not a newbie by any stretch either, right? It's, 15 at least, forgive me, I should know this and I don't, but maybe you know offhand how many years.
Almost 19.
Sorry?
Almost 19.
Oh, it's 19. Wow. So it's certainly not a newcomer. It's and it's obviously changed in terms of how sort of what an institutional kind of centerpiece it has become over the course of the 19 years. So I guess maybe if you want to talk a little bit about how, sort of the different constituencies in the press corps, having spent some time with, true legacy media, NPR, and now SCOTUS blog, which again is sort of in its own category, I would say, how, if at all, the role of NPR versus SCOTUS blog is different when it comes to the court. And then maybe, since we could get to TikTok later, but we may as well just get to it now. You've been making TikToks. My podcast co-host Leah has been doing that as well. Obviously, there's not been a lot of Supreme Court commentary on TikTok, I don't think, until Leah and you started doing videos. So I guess what is the advantage of taking Supreme Court content and using these kind of new media to try to present them? So I'm curious about your thoughts on both of those questions.
Good questions. And I would say Leah's TikToks are great. And also Bloomberg Law has been doing Supreme Court TikToks, and all of them are women, which I particularly enjoy. So all of the Supreme Court commentary right now on TikTok is coming from really smart women. So SCOTUS blog is known for its in-depth explanatory journalism, and also for being a resource for journalists and for the press corps and for court watchers generally. We have all of the filings in every case, and we kind of try and be a resource to everyone. And so my job has been to use new media to do that explanatory journalism piece in new ways and to a new audience. And thinking about TikTok, Tom Goldstein is actually the one that encouraged me to do it. I was hesitant because I wasn't sure that there would be any room for a Supreme Court nerdery on TikTok, but there is, lo and behold. And so two reasons why I think that it has been important. One, it's a way for SCOTUS blog to reach a brand new audience, and not just younger people, but people that just don't consume legal news and news about the court on a regular or even irregular basis. And they can spend 60 seconds or 30 seconds learning something. And the other piece is, I think after the election and the conversation about the Supreme Court and the Supreme Court's even questions about the Supreme Court's role in the election and in the post-election challenges and all of that betrayed a lack of civic education in a lot of folks. And one of our goals as an impartial translator, to use your word, is to kind of shore up those pieces that were missing. And so if I can, in 60 seconds, explain a really complicated case that's interesting and it teaches you something about the court or how it works or what it's doing, and not just the headline making 5-4 decisions, but the ones where they all agree and unique things that happen that we all know and get used to as court watchers and in the broader court community. That's one of my goals with TikTok. I'm still new to it, so I'm still learning about the audience and what people are interested in, but that's kind of our two primary goals in creating that type of content. It's still explanatory journalism. And you ask about voice, I try to have that impartial voice in channeling SCOTUS blog's intent and purpose. But that doesn't mean that we can't truthfully kind of shed light on the historical injustices at the court or even the current inequities that are happening. And I've tried to do that too through TikTok, talking about certain decisions that the court has made. And so we're still finding the voice, and it is still the traditional SCOTUS blog impartial voice, but we're exploring it in the new mediums, I think.
And so, Josie, let me bring you in and ask, obviously this event is largely about the Supreme Court, but I'm curious to hear sort of your take on, obviously you run an organization that looks at the law, the legal system much more broadly than just the Supreme Court. What is your sense in terms of the broader legal commentariat? How much of that is consumed with Supreme Court kind of commentary? And if the number is high, and I think you're going to say it is, but I don't want to put words in your mouth, what is that? Does that have a distorting effect on, or does it consume oxygen that would better be or also be spent looking at sort of other parts of the legal system and other kinds of legal impacts and questions?
Yeah, I think the answer to that is absolutely right. One of the things that really matters to us at the Appeal is covering local stories, right? Covering local and state politics and judiciaries and court systems and prosecutors. And the reason being that these are the systems that actually drive what happens to people in their lives, and really highlight the sort of randomness of how the law functions, right? You can do the same thing in a county next to another county, a county one county over, and what's going to happen to you is going to look very different. It's going to look very different depending on what time you're arrested. It's going to look very different depending on who arrests you. It's going to look very different depending on which ADA takes your case. And I think what, the sort of structure and the barriers that we imagine this system to have, and that it often has on the federal level, at least more of them, it just doesn't really exist, right, in practice. And so it was interesting when Sarah said she works for people who are interested in appellate law and interested in Supreme Court, nerds. I think we're doing the exact opposite, because a lot of who we're talking to are people that not only this is not their thing, but it's intimidating, it's scary to them. And when you're talking about an opaque system that is, driven by man and not God, how do you say, this is how it works and this is how it can change? And so, it is, our podcast, Justice America, the whole goal of it is that you can come in at any point on any of the 30 episodes and get what, and have, you could start wherever, because that's how people who don't have this background process this information. And so that's sort of a niche we're trying to fill, both the trying to translate a complicated system to people who aren't involved, who don't know much about it, but also focusing on the what happens on the local and state level. I mean, the Supreme Court's obviously very important, but you think about death penalty cases, everybody gets very, very up in arms, right? The night when we all know what the Supreme Court's going to do. All the decisions have been made. And yet this is the point at which it feels really tangible to people. And so we're trying to make these other steps tangible to them as well.
So let me pivot a little bit to ask a question about how much you talk about like law and how much you talk about politics, and sort of what the right balance is when you're kind of talking about the decisions of the Supreme Court. And there's an article I want to mention by Christina Tilley and Barry Sullivan that was published last year about the kind of changing face of Supreme Court journalism, and suggests that there's just a lot more politics talk when the print press, at least, reports on what the Supreme Court did in a particular like high stakes case than there was 50 years ago, when the law and legal doctrine were sort of foregrounded in the written commentary, at least. And so assuming that's true, that there's more kind of open, frank talk about political motivations or ideological predispositions of the justices, I guess, so how do you think about the sort of relative weight of those two when you're trying to explain something the Supreme Court has done? Explain, critique, praise, whatever it is you're doing. And if it is true that there's just a lot more frank politics or ideology talk and less kind of sort of legal doctrine talk, is that actually a good development, or is it a development that risks undermining the perceived legitimacy of the court? I don't. Josie, maybe it's stipulating that you guys are casting a much broader net than just the Supreme Court. You do obviously talk about Supreme Court cases. I'm curious how much we do and should talk about the political or ideological motivations of the justices.
Yeah, I think it's an interesting question, and it's a reminder that we need all of these different forms of journalism that we're discussing, because if everything was like, we kind of jump straight to politics and ideology. I mean, like, we're just not, we are pretty explicit. I mean, the person who writes most about the Supreme Court for us is Jay Willis. And I mean, it's no surprise that Jay believes strongly that like, this is all about ideology and politics for people, right? I think you need both, because I think that the longer away I am from law school, the more I really understand why they talk about norms so much, right? That there is a value in norms and procedure and standards, and just and pretending like they don't, that the justices don't care about them at all allows the justices to not care about them at all in some sort of like way. But I for us, like, it's been really important to, again, make this system tangible to people. And I think that especially the Supreme Court, people hear a case result, and a lot of, people like, they think they don't understand how this decision was made. And in some ways they don't, but in other ways they do. These justices are human, right? They make decisions, they make human decisions. And so I think that we definitely are more towards the politics ideology side. I don't think that that's necessarily good for everybody.
Or the only way to do it. I think it's such a nice point. So
exactly.
There could be a spectrum, and maybe like a healthy discourse has components of all of this. But so Katie, I'm curious about you. So you sort of said, like, we're really kind of laying it out like in a very kind of neutral journalistic way. Is there something lost if the doctrine is all that you are describing when you break down for the very wide readership what it is the justices have done in a particular opinion?
Yes, I think we're thankful for all of the other court commentators that sort of amplify the meat and potatoes that we provide. But I think, we also participate in some of that discourse, and certainly saw that toward the end of last year, particularly after the election. So I think in terms of our voice, we contribute kind of somewhere middle of the road, but it's still impartial. We all have our biases. Every journalist has a bias, but in that impartial voice, I think we do that, but it's important to have those other voices that explain it in a different way that perhaps resonates with the audience. It's all a part of the goal of translating this least transparent branch to the public who deserves to understand it. What my ideal would be, and I'm sure we'll talk about it later, is to have cameras in the courtroom so that our coverage generally becomes ancillary and just becomes explaining what they're seeing, rather than the entire filter through which the American public understands the court and it working. But that's probably for later in the discussion.
Well, I actually want a quick follow-up because you mentioned SCOTUS blog in the fall between the election and the inauguration. There was a little bit of a break from the traditional SCOTUS blog, neutral presentation of arguments and facts. Twice, 3 times, I don't actually remember how many times, but on the blog, SCOTUS blog basically, in a very full-throated way, took the position that election fraud claims were baseless, and Supreme Court wasn't going to actually take up any of the Texas original jurisdiction challenge to the voting changes made in other states. And I actually don't recall all the specifics, but I'm curious if you wanted to, since you mentioned it, shed light on a decision, and assuming that the SCOTUS blog leadership made the decision. Am I right that it was unprecedented for SCOTUS blog to have taken those positions? And what do you think drove the decision to do that?
Right. So I think for the first time in almost 19 years, we ran an op-ed, and it was from our co-founder, Tom Goldstein, who said, to your point, that there was no merit to these challenges and that the Supreme Court was not going to get involved. And SCOTUS blog gets its legitimacy from being impartial. And so it was worth it to us to use some of those legitimacy points to really explain to the American people what was happening and what wasn't going to happen. And that was, I know we have all kind of looked past it now, and we are past it in some ways, but that was a really intense time, especially surrounding the court and the rhetoric that was going on. And we thought that it was really important and kind of would be a powerful message coming from us in particular, call it ego, that this was not going to happen, and that was not right, and it was incorrect, and there were some misconceptions about the court's role and what they were going to do, and that was largely Tom's decision. So I won't speak for him, and the op-ed speaks for itself, but I was glad that we did it, and I thought it was an important point to be made, and I thought it was well done coming from us in particular.
Sarah, let me bring you in on this question. So background in politics, so doing more legal commentary now. How much do you talk about the political or ideological motivations of the justices? How much on the sort of spectrum of the appeal to SCOTUS blog that we've just been describing? Where's your commentary, and where do you think the optimal sort of place along that spectrum is?
So one of my favorite things to do is to take headlines from outlets that I think are far too political, far too simplistic, therefore, and break down why I think it's not that easy. I'm trying to think of a good example of a recent case. I mean, Bostock is sort of everyone's go-to example these days, but I'll use it too. Bostock was an intra-family fight. And so you can actually see what's going on of the fight between originalists, textualists, this new conservatism that is worming its way into the legal conservative movement, the sort of Adrian Vermeule common good constitutionalism. And then you want so desperately to hear from Kagan and what she's thinking in all of this. And so breaking that out and making the point that Josie makes, I think, which is these people are humans. They are not just like Republican automatons, Democratic automatons. They're fighting amongst each other. They're incredibly frustrated with the Chief Justice. Here's how you can tell. Here's the side eye and the footnote. And so in some ways, it's not rejecting the political side, but it's far more interesting and complicated, and it's not red team versus blue team. And I think one of the benefits that I bring, I come from that family, right? I've been at the Department of Justice 3 times. I am married to the former Solicitor General of Texas. It's funny, I don't have press credentials to the Supreme Court. I'm barred in the Supreme Court. I sit with the lawyers at the Supreme Court for oral argument. I know a lot of the advocates. And so I feel like I can bring a little bit of hey, here's the reputation of what's kind of happening with all of this. And I think that the overt political coverage that simplifies it so much is a huge disservice to the courts, actually. I don't mind the political coverage. I mind it being incorrect, if that makes sense, too simple. That there is politics at the court. Of course there is. There's ideology at the court. But if you make it red team versus blue team, you're missing most of the story. And that's what I think hurts the legitimacy of the court and isn't very good journalism.
So let me follow up because now you've revealed yourself to be an insider, which I think we knew anyway. But is there a larger intra-family fight happening in the conservative sort of legal world that Bostock is just a reflection of, or is that a one-off?
Oh no, I mean this is to use a food fight thing. Maybe it started with some French fries being pegged at the back of the chief's head or something, but there are puddings being thrown at full force across the room. you know,
Okay, no metaphors. Give us
described-
more details. We want.
Yeah, I've described this as a 3-3-3 court. I think there is an enormous amount of frustration. There has been an enormous amount of frustration between the chief and Alito, for instance. I think that has just blown up when you look at June Medical. And then when the chief has Kavanaugh and Barrett with him, that's making Thomas and Alito even more frustrated. I'm not sure how frustrated Gorsuch is. I do put him in the Thomas Alito 3-pod, but I think he's there for different reasons. And I think we saw in Bostock what that can look like. He is just a true textualist. He's very interested in the words, and to quote Katie's pod, words have meaning. And that's not why Alito and Thomas are there. And so there's tension within that 3-pod. There's a large amount of tension within the Roberts, Barrett, Kavanaugh pod, because all three of them are there for different reasons, even if they're sort of bedmates for a time being. And then you have the shots over the bow from the Vermeule camp, this like scrap the last 38 years of legal conservatism. We need to be outcome-based, not process-based, because these outcomes are stupid and we hate them. That's a shot at all 6 of the current conservative justices. I don't think we've seen them respond to that yet, but I think we will.
Okay, so that's fascinating. I want to follow up, but I feel like let's move on. So Steve, let me bring you in a little bit. So I think so those kind of like internal dynamics that Sarah is describing are fascinating. You know, we all kind of like watch these shifting dynamics. I think that's a really interesting sort of 3-3-3 scenario that you posit. I would say Barrett, I just don't think it's been there for long enough for us to really know where she resides. But I think it's interesting, and we will have a lot more information by the end of June about sort of how stable any of those coalitions on the court right now are. But obviously there's a lot that is kind of in flux. I'm curious, Steve, like, so the kind of, we're not really doing the peeking behind the curtain. So Katie mentioned, you know, least transparent institution in American public life. I think that in many ways, people will push back and say, well, they show you their work with their written opinions, and that's all you need to know. But like, I'm not particularly moved by that argument. It's a deeply non-transparent institution. I think that anybody who spent a lot of time around it has to come away with that conclusion. But should there, you know, I'm curious about the kind of dynamics as between these. Is there a role for kind of, so you know, Totenberg, some, but like lots of, you know, a previous generation or current generation and previous generation of Supreme Court reporters would do a lot of, you know, kind of source cultivation, had close relationships with the justices, which like, I don't know if Sarah was alluding to, I don't know if you got those, but you're like a degree separated from some of them. So you maybe go to cocktail parties with them. I don't know. But like, is there some value in like that kind of beat journalism in which you're actually kind of, you know, developing sources in a way that more traditional journalism would, but that, you know, a lot of Supreme Court commentary is literally just going to the arguments and reading the opinions and trying to break them down. Is there value in that former type of reporting on the court? Should we do more of it? And then I'm curious, you shook your head vigorously, I think you did, at the cameras in the courtroom suggestion. So I'm curious what you think of that prospect, which rears its head every so often.
Well, that was Sarah, I think, shaking her head. I don't have such strong feelings about cameras in the courtroom either way, but just there's a lot of interesting points that have been made that I wanted to pick up on. Sarah's point about Roberts and Alito being at odds, I think, is a story. But also, I mean, I've seen Gorsuch and Roberts at each other's throats constantly. That seems like the bigger one, personally. You know, your original question about politics and law, and are commentators and journalists focusing more on politics recently, and should they be? I have like a global thought and then a more personal one about that. The global one is, it would be strange, I think, given what's happened in the past couple of decades, if Supreme Court commentary and journalism wasn't focused on politics in the way that it is. Think about, I mean, Bush v. Gore, think about Citizens United, think about Shelby County. These are cases that were not just 5-4 divisive decisions that stirred up passions. Each of those address the way that American democracy operates, right? So the Supreme Court is actively shaping the guardrails of American democracy. And so if we are, if we're just looking at the legal doctrine and, this side says this and this side says that, without looking at the more political ramifications of the decisions, it would be strange. And I think we'd be doing a disservice to our readers if we let that fly. And, I'm thinking back to the Tom Goldstein op-ed. That was remarkable. When I read that, I had the impression this is I'm mad as hell and I'm not going to take it anymore moment, right? Like, this is too much. This issue about election fraud in the 2020 election, it was just so far beyond the pale. And this Texas case was so far beyond the pale of normal disagreement between parties that I was picturing Tom Goldstein like his collar getting hotter and hotter until he eventually had to write that. And he wasn't just making the claim that this is beyond the pale. He was urging the justices to make a full-throated presentation as to why this Texas case was so misguided and why Texas had no standing and the other states that had joined it. And not just to give a one-line, this case, cert denied. We didn't get anything more than that one line, but I think it was sufficient. But I understand where that came from. So I think that's the more global point. The more personal point, when in graduate school, I was looking at issues at the intersection of political, moral, and legal theory. It was all about principle for me. I regarded the behavioralists, who look at judges, what causes judges to make different decisions. I thought that was incredibly crass. And, why aren't they looking at the Constitution and history of its interpretation, as opposed to, how old the justice is, or what their mutual funds look like, or all these other factors that may go into determining how judges rule. And I guess I was naive that first day at the court, and I think I was naive in that way too, in like looking at everything in terms of principle and who makes the better argument and where's the clash in the argument, and presenting cases in that way in my writing. I've come around to acknowledging the political side more, and the people who study judicial behavior actually have a lot of interesting data to share with us. So I've integrated that into my coverage without resorting to what I think some commentators do, which is to say, you've got Republican judges and Democratic judges, and, as Sarah said, red team, blue team. That's simplistic, and it doesn't do, it does a disservice to the court to talk about it that way. So I'm sort of at a middle position between looking at the politics of the court as the most important thing to consider, and looking at the way that the doctrine has been evolving and shifting.
All right, so I've got more questions, but I think that Anna and Becca were going to pop back in and actually moderate some of the questions from the audience. So welcome back, you guys. I'll turn the moderator mic over to you.
Thank you so much. And thank you for this really engaging and fascinating discussion. I've really been enjoying it from my sneaky camera off view. We have one question that I'd love to bring to you all. It was a question about how media coverage of the court reflects changes in the court itself, and specifically how journalists and other folks are commenting on the shadow docket, which I know has been quite the hot topic this term. So I was wondering if folks have a view on that.
I'm sure people do. I see Steve nodding. So please go ahead. Yeah.
Yeah, I was wondering why 45 minutes had passed and we hadn't brought up the shadow docket.
I knew somebody in the question.
Transparency of the court. Right. So much is happening there. And, no oral argument, limited briefing, quick decisions. And I think that I have a feeling that the testiness between the justices and the sort of lacking judicial craft that we've seen in the evolution of all these COVID versus religious liberty cases, that it may also be a reflection of the fact that the justices haven't seen much of each other in person. They famously shake hands at the beginning of every day together in every argument. They haven't been in the same room together until recently when they've been having conference. So it feels like they're less cohesive as a group over the past year than they have been. And I think the quarantine may have something to do with that. And the way that the shadow docket has been kind of disappointingly moving might be a reflection of that, in addition to the very nature of the emergency docket that doesn't have much time or space for written and oral discussion.
See, there's a behavioralist, legal realist sort of take on what we've seen coming out of the shadow docket. Yeah, no, it is, and maybe I'll take a moderator's privilege for a minute and say, like, I actually have been shocked at the amount of lawmaking they are doing on the shadow docket, and in the last year in particular. So I think since Will Bode coined the phrase, and Steve Floddick has done really good and important work charting the growth of the use of the shadow docket. But I don't know if anybody's actually looked empirically at the last year yet. Over time, I presume that people will. But anecdotally, it is really kind of stunning just how much, just really since, I would say, the last 15 months, or since I guess about 13 months really, since we all sort of entered lockdown, and the early COVID cases. April, I think, was the Wisconsin primary, the RNC versus DNC case over the summer, additional election cases. Some decided with no opinion at all. Some decided with these, pretty sloppy, obviously very fast orders that were issued, many very testy, as Steve mentioned. But you've had that, election shadow docket, the COVID shadow docket, the death penalty shadow docket all fall with the court in some cases reinstating over-reasoned decisions issued by lower courts. That same day executions that then went forward, the federal executions I'm talking about in particular. You have kind of a, contraception, at least, if not, like abortion shadow docket, like you've had at least the abortion shadow docket is really only a couple of cases, but I think you have these kind of subsets of the shadow docket that have evolved. And I do think that I hope that as they return, hopefully, to in-person arguments in the fall, we will see less of that. But I mean, it's just that, if kind of the giving of reasons is one of the kind of essential components of the doing of real justice, the lack of reason giving or sort of full consideration that attaches to decision making in the shadow docket, I actually find pretty shocking from a court that I think does care about at least the appearance of and often the substance of procedural justice. There just doesn't seem to be that, but that's a moderator's privilege. I'm sorry, I'll stop talking now. Does anybody else want to get on the shadow docket? Sarah, please go ahead.
I have two just quick observations. One, I wish there were more pressure on the court to grant more cert cases. I feel like the shadow docket's coming out of the shadows in part because there's so few cert grants that a lot is just getting shifted to the shadow docket. Second observation is we've talked about the, red to blue spectrum, but I'd like to also mention a different spectrum, which is the institutional to ideological spectrum, with Robert sort of being the chief institutionalist and maybe Thomas being the chief ideologist, like regardless of the institution. If he decided that the Constitution said that the Supreme Court, shouldn't exist anymore, he'd be like, well, it doesn't exist anymore. And Roberts would be like, no, this is more important. There is something above ideology. And I think that is playing out in the shadow docket in a really interesting way. And you mentioned, for instance, the abortion shadow docket. We're about to get a big abortion shadow docket case coming out with the Tennessee thing. So I wonder whether we'll see sort of that institutionalism of, no, it's the Roberts opinion that you need to follow from June Medical, not Breyer's, and that sort of institutional line, down to the ideological side of that spectrum of it's abortion.
Well, then there's the question of what the June Medical concurrence even means, which the Sixth Circuit could not figure out a few days ago.
Correct.
Should do another question?
Yeah, let's do another question. I think sort of another related shadow docket legitimacy question. At the end of the day, sort of to Sarah's point, there is this overarching legitimacy question, and that has implications at the court, but then also in terms of how the public receives their decisions. And so this attendee wanted to know sort of how you think about the court's legitimacy in light of recent decisions in cases like South Bay, and sort of how, as they prepare to address sensitive and complex issues, as they always do, but given the political scene, it looks like we're going to be seeing cases on abortion and some really hot topic issues. Will there be an acceptance of its decisions like we, expected in previous times, or what does that look like? I mean, famously, the Supreme Court doesn't have an army to sort of have its opinions be followed. So what does this look like?
Katie or Josie, any interest in what it sort of what this kind of shadow docket and some of the cases that are likely upcoming could sort of do to the court's, legitimacy in the eyes of the public?
Yeah, I think it's an interesting question in terms of, but there are two kind of questions going on. One is like, will people accept the results? And the other is, do people see them, does the public see them as legitimate? I think the general perspective on government across the board is more skeptical, right, than it has been in a long time. I think that it goes both on the left and the right. And I think that also goes for the court. But that skepticism and how it actually translates into behavior and decision-making by both like elected officials and people on the ground is not, the connection there isn't as clear to me. So I don't really predict like a total rejection of a Supreme Court decision anytime soon, but I do think the fact that these are all sort of socially constructed and not prescribed and not, is something that people are more and more aware of. And frankly, I just think that's a good thing. I think that we should all, there should be a balance between the perspective of the legitimacy of the court in the sense that that's how it should exist in a democracy. And so I think the increased kind of questioning of that is not all bad.
I echo those comments, and to harp on a previous point that I made, I think that questioning legitimacy is a good thing, and I think increased transparency is a good thing, and the more sunlight that we can shine on the shadow docket and on the court and how it works is a good thing. And that's why I think things like having cameras in the courtroom, of course, people are going to continue to question the legitimacy of the court, but it's while they're learning about it and they're understanding how it works and how it has worked for so long. And there have always been a Supreme Court press corps, but there's an increasing understanding of the court's role in our democracy. And to Steve's point about the role in creating those guideposts for our democracy. And the more sunshine and sunlight on that, the better. And questioning is a good thing. That's how people learn. That's how we evolve. And that's how people understand when they go to vote, what that vote means for the Supreme Court, and think about that. And I just think, more transparency and more questioning is a good thing in a democratic society. I agree, Josie.
Should we get one more quick one in? We have a bunch of questions. I'm sorry, I promised to get to as many as we could, and we got to only a couple.
If people are down, we could do one more. Okay, let's do it. Let's go with this one. So we've had a couple questions about advocates before the court and sort of the interesting position that they're in. There was one question about sort of those who are advocates before the court, but then also commentators on the court and the potential sort of conflict of interest there. And then another one about how, we've talked about sort of looking at the ideology of the justices, but then sort of there's this question about, advocates play a very important role, I would hope, in terms of asking questions about legitimacy, but we would hope that advocates, play a huge role in the way that the decisions come out. And so is there sort of a gap in some of the coverage and scholarship of like who gets to shape the law, and, there's not the same scrutiny of a Supreme Court, advocates. I'm sure many people, hopefully a good amount of people know at least one justice, but I think they're most everybody. I mean, I don't know if I could name more than two off the top of my head. So is there a gap in sort of the scrutiny that we give to advocates?
And I mean, even, the government, like the Solicitor General, hugely important position, not a household name for most people, right? And certainly that's true about private lawyers as well. Steve, any thoughts on that? Sort of either commentary, like advocates who are also commenting on the court, there's like lots of concerns that get raised. People take the position that you really shouldn't be doing both, or that advocates are using these other venues like podcasts and stuff to kind of lobby the justices. Should there be like a bright line between those two activities?
I think that's a question for the lawyers. And I've asked several prominent Supreme Court litigators who are also active on Twitter and critical of Supreme Court decisions and particular justices' opinions at times. Like, how do you do that? You're going to be before the justices in a couple of months arguing a case. Is it risky? Does it feel weird for you to be engaging on Twitter in the way that you do. So yeah, I'm not one of the lawyers making those decisions, but it seems like something that would be a kind of a tricky issue. I mean, it's similar. It's different, but it's similar for a journalist who is trying to cover the court in a fair and balanced way to present both sides of every argument, while also partaking on Twitter and other places, or writing op-ed pieces that show that the journalist has a particular take on certain issues in certain cases. So I've thought about that from my point of view. I think it's a little more serious for a lawyer who has paying clients who, you know, would want them to not defend justices whose votes they need. I'm curious if any of the lawyers on the panel have a thought about that.
Just one observation about the actual market or whatever of what's going on in the Supreme Court practice. More and more advocates are having to offer their services for free. And there's fewer and fewer that are paid. At the same time, these outside groups that used to hire the Paul Clements or whatever of the world are having their own in-house people argue more. I think, as Justice Breyer said, the oral arguments are 5% or less of what's going on. And so if you don't think that the oral arguments are as important, and you realize that the media covers the oral arguments wildly outsized to how much they actually matter to the outcome, you're far more likely to have your in-house people do it and get the attention in-house rather than let Paul go get all the attention for you. I think those two dynamics are very interesting in advocacy right now. It's the result that I predict is that there's going to be fewer people being able to go into Supreme Court advocacy because there's not the money there. If everyone's offering to do it for free, you've got to have something else that's making money for your practice. So that'll be sort of odd and a change at the Supreme Court if you no longer have sort of the professional class of famous advocates.
I think it's a fascinating note. I would love to hear more, but I do think that we should probably wrap. I don't know if Anna or Rebecca, you guys have final words, but okay, no, well.
Please
sorry.
go ahead.
No, I was going to say thanks for inviting me to do this. I thought it was fascinating and I learned a lot, but please, you send us off.
Well, I was going to say thank you all. Thank you, Professor Shaw. Thank you, Steve. Thank you, Katie. Thank you, Sarah. Thank you, Josie. Thank you all for taking an hour of your time tonight to talk about this really important topic and to educate us all from all your expertise. Big virtual round of applause from everywhere they are. Again, we were so grateful to host you all, and we're just very grateful for your time and are very thankful. So again, thank you for the sake of being repetitive, and we hope everyone has a great evening. Take care.
Thanks.